Okay, I want to do one more video about dormant commerce before we move on, because we've talked about the general principles and the outline, right? And we've talked about the market participant exception and the United Haulers exception to strict scrutiny when a state discriminates or a city discriminates, right, against outsiders. But I want to make sure we wrap this all up with some application to a couple of cases that have already happened, and also talk just for a minute about current events and how dormant commerce principles might play in. So first of all, I want to call your attention to a note case in the book called Dean Milk versus Madison, Madison, Wisconsin. I've mentioned this case before, and I want to emphasize this case in the context of a nightmare scenario that I had on an exam, I don't know, a couple years ago, where I had a fact pattern where the city of Tampa placed a tax on out-of-state residents renting hotel or motel rooms in Tampa. If the tax only applies to people coming from outside of Florida, and it was a spring break tax type of thing, right? That Tampa was placing on out-of-staters. So if you're from Florida, you pay one rate. If you're outside of Florida, you pay another rate. There's some pretty obvious discrimination going on there. And I had way too many students say that that doesn't violate dormant commerce because Tampa is not a state, right? And what I had to write in the margins there, every time I saw that was, you just told me, without knowing that you told me, that you did not read Dean Milk versus Madison, because Madison is not a state either, but the court certainly held that the dormant commerce principles do apply to the city of Madison. Madison, Wisconsin enacted an ordinance that you're not allowed to sell milk within the city, right, unless it was processed within 5 miles of the city center. Really goofy kind of a law or ordinance. And there was obviously a dormant commerce challenge to that. Now, this is to be distinguished, right, from the United Haulers case, right? Because you could look at the Madison ordinance as sort of a flow control thing, right? If you're going to sell milk in Madison, it has to be processed at these particular processing plants within 5 miles of the city center. The difference is that Madison's ordinance didn't favor a Madison-owned processing plant, right? Madison's ordinance favored private businesses, right, within 5 miles of the city center. Those businesses that were processing milk. So it discriminated in favor, right, of in-city private business interests at the expense of obviously all, right, milk processing businesses outside of Madison. So that being the case, you'd apply strict scrutiny, right, in a case like that, because there is no exception under the market participant doctrine or United Haulers. And the state's going to be fine on the compelling interest thing, because who drinks milk? Right, think about that for a minute. Yes, children. Right, so Madison's going to be fine on that. They're going to say, save the children, we need a healthy supply of milk. I mean, for wholesome, the word wholesome, right? We need a wholesome supply of milk for the kids. As usual, the most dangerous part of strict scrutiny is the means part, right? Courts usually strike down ordinances, laws, policies, etc., under a strict scrutiny on the narrowly tailored means end of prong of the strict scrutiny test. If you want milk to be safe, if I'm a court, all I have to do to strike down your law, Madison, is I think of one better way to keep your milk safe. How about you inspect it? There you go, right? So, if you can think of one better way to achieve whatever it is the state says it's trying to achieve, or the city says it's trying to achieve, under strict scrutiny, that means that the means chosen by the city are not narrowly tailored because they're not the least restrictive possible, right? The least burdensome on interstate commerce possible. So that's Dean Milk. I also want to call your attention to a case called Hunt, right, versus Washington State Apple Advertising Commission, which was a case out of North Carolina. North Carolina passed a law saying that if you want to sell apples in North Carolina, they have to be sold in containers that either have a USDA grade on them or no grade at all. Okay, now I hate apples. I've hated apples since I was a kid. I don't understand the appeal of such a grotesque, right, devil's fruit. But apparently a lot of people like apples. And if you're an apple connoisseur, then you probably know that the best apples on the planet, or apparently in the entire universe, right, are grown and harvested in Washington State. So Washington State has its own grading system for apples because they're hoity-toity, right? They've got the best apples in the world. So a Washington grade A apple is better than a USDA grade A apple. And, you know, again, apple connoisseurs, apparently when they're shopping, they know what they're looking for, right? You want a Washington. So Washington apple growers want to sell, right, their apples in containers, crates that are marked with Washington apple grades, so that consumers know they're buying Washington apples and they're Washington grade A apples. Now, here's the funny thing about Hunt and why I want to mention it and make sure that it's in your notes and in your mind. The Hunt case, when you look at the law, on its face, it is even-handed. That's the weird thing about this case, right? You're going to see this a lot in common law too, right? You look at the law, you look at it on its face, right? On its face, is there a problem with it? Sometimes on its face, it looks perfectly innocent, right, and neutral. But when you dig deeper, you see that there's something else going on. So this, and again, in Hunt, the North Carolina law simply says that if you're selling apples in North Carolina, think about this, if you are selling apples in North Carolina, you will either sell it in a crate that's marked USDA grades or no grade at all. There is nothing in there, right, that treats in-staters and out-of-staters differently. It doesn't, right, on its face. The thing is that the Supreme Court knows what's going on, and they decide, for once, they're not going to pretend not to know what's going on. The record discloses that the reason North Carolina, right, enacted that law was that North Carolina apple growers were getting killed by Washington apple growers because people buy Washington apples, right? So the state legislature was lobbied by North Carolina apple growers, right, to change the law so that Washington apple growers could not sell their apples in crates marked with Washington grades. What this tells you is that discrimination, okay, and we've talked a lot about that. When does a law discriminate against, right, out-of-state, or against interstate commerce, right? And typically, a law that discriminates against interstate commerce will do so on its face. For example, it will say no importing blank, you know, X, no importing widgets, right, from any other state. Okay, so it's right on its face it discriminates, so you go straight to strict scrutiny. You also, however, want to look at the fact pattern to see, even if on its face it looks like it's even-handed, is there evidence in the fact pattern, right, to indicate that whatever state is in question or city is in question, are there actual facts in the fact pattern to indicate that they are actually targeting out-of-staters, right? Either out-of-staters generally or people from one particular other state. Either way, you're going to get strict scrutiny. So I hope that's clear. You know, the court says, and this is the again, language you need to know, right? If you get a bar exam question on this, you need to know this language. If a law has the purpose or effect of discriminating against interstate commerce, right, then strict scrutiny applies. Now, I'm going to tell you, I find that to be a very sloppy way to put it. It's not really a purpose or effects test. It's really both. You know, either way you slice it, there's a purpose to discriminate, right? It's really, does it discriminate on its face, or as applied when you look at the evidence, right? You know, is it purposefully discriminatory, right? Even though on its face, it looks like it's neutral. So, but the language, again, the language courts use is the purpose or effect, right, to discriminate against interstate commerce. I would suggest that the way you spot that, okay, is you either say on its face it discriminates, that is easy to spot, right, but be careful, if on its face it does not discriminate, just look at the fact pattern and see what was going on in the state legislature, what was going on in the city council, what discussions did they have, what public statements did they make, right? Is there evidence here, right? Sometimes we have to infer, right? But is there evidence here that what was really going on here was an attempt to target out-of-staters, right? So if a law either does that on its face, or if the facts of the fact pattern indicate that that's what the state or the city is doing, then you would apply strict scrutiny. If it's a close call and you can't decide, obviously do both. Say a court might say strict scrutiny, so here's that. A court might say Pike, so here's that, right? So you never freak out in constitutional law when you think there's a close call, right? When there's a close call, just, don't leave points on the table, right? Do both. And as you know, for this particular exam, you're going to have plenty of time. So, but you are going to have a word limit, so you want to be careful. More on that later. Okay. So in the Hunt case, you would apply strict scrutiny. Is there a compelling interest? Who eats apples? Children eat apples, an apple a day, blah, blah, blah. Right, so you're going to have a compelling interest, right? They say, well, they're going to try to keep a nice, beautiful, safe supply of apples. And North Carolina argues we want consumers to have accurate, right, information about what they're buying. Then the problem is that under the narrowly tailored means prong of strict scrutiny, the court says, if you're saying that you want consumers, that the whole purpose of your law of having crates that say USDA or nothing at all, if the purpose of that law is to give consumers more information, guess what? The law accomplishes, not only does not accomplish that, but accomplishes the opposite, right? Because now North Carolina consumers have less information, all right, at their disposal in terms of the quality of the product that they're buying, right? North Carolina consumers who go into a store wanting, right, to purchase the best apples in the universe are now deprived of that opportunity because North Carolina won't allow the sale of apples in Washington grade A crates. So there again, strict scrutiny would apply and the law fails. Finally, just make sure you give some thought to current events, right? There's all kinds of talk about federal versus state response to the coronavirus, and you're going to see probably states, well, I mean, I don't want to predict that, but you hear talk now about excluding people from other states, Governor DeSantis in Florida talking about excluding people from New York, right, keeping them from coming into Florida, right? Those types of things that discriminate against out-of-staters, they're going to get strict scrutiny, but you want to keep in mind, right, that it is possible to survive strict scrutiny. Probably, especially in an emergency situation, right? If, obviously what they're going to be able to argue, if states do that, if states exclude out-of-state, right, either out-of-state people or out-of-state products that might be infected, right, whatever they're excluding, the interest is going to be no problem, right? The interest is going to be saving life. So, all right, fine, that's not going to be a problem. The question is going to be, are the means narrowly tailored? And you could see probably a judge, look, if I call a couple experts, right, a couple public health experts, and get them on the stand and get them to say that there's no other way to protect Florida than to exclude people who might be infected with the virus, or at least to protect some Floridians and save their lives, that there's no other way to do that, there's no better way to do that, there's no less restrictive way to do that. If I can get a couple public health experts to say that, then that might pass strict scrutiny. But I want you to be thinking about this stuff, right? These rules and cases that we study, they have an impact, and they're applied, right, every day. I'm going to tell my con law 2 folks about Texas, basically suspending all abortions, right, unless they're required for the health and safety of the mother, so, or of the woman who wants to have an abortion. So you see these things, right, we talk about them in class, and then the next thing you know, it's in the news. That's one of the fun things about constitutional law. Well, I shouldn't say that this is fun, but it's one of the interesting things about constitutional law. So keep that in mind. That's a wrap on dormant commerce. I wanted to just get a couple more cases in so you can start thinking about how to apply this stuff. And we'll come back soon with more on privileges and immunities, a contracts clause and all that. Stay safe, and we'll see you soon.